SJ, welcome to Mvskoke Radio, your weekly source for tribal and community news, interesting guests and discussions, plus a local events calendar. SJ, Stone Go, Gary Fife, Joe Jifkidos, Mvskoke Radio, Mabo Hedget, Wedgekit. Can't get it out. Welcome to our program on this frigid Okmulgee morning. Sun shining, but dang, it is cold. Got a couple of things we'll be sharing with you on today's program. First of all, it is time for a recycle event coming up this weekend on Friday. And we have Mr. James Williamson to talk with us about what's going on there and put out his call for recycling and how our tribe is doing. In the second section, we have excerpted parts of the Supreme Court arguments for the Indian Child Welfare Act in the Burkine versus Holland lawsuits before the High Court. It is excerpted because the entire presentation was 3 hours long, so we'll try and just kind of bring you the opening arguments on that one. But first of all, let's get on with what we've got. Good morning, Mr. Williams. Appreciate you being here.
Certainly. Good morning, Mr. Fife, and we're certainly glad to be a part of your program today, and thanks for the invite, and we certainly appreciate that. We're going to talk about today is about our America's Recycle Day, formerly known as National Recycle Day, but somebody changed the name, so now it's America's Recycle Day, but we're calling it Mvskoke Nation Recycle Day. And that'll be this Friday, November 18th, 2022, starting at 9 o'clock and running through 3 o'clock p.m. And our big thing there will be a document shredding truck that'll be there from 10 o'clock to 1 o'clock. Or until the truck is full. So far, we've never made it to 1 o'clock. It usually fills up before noon or just right after that. So if you want your documents shredded, bring them on out. We'll shred them. The only thing that we ask is no big 3-ring binders or the black large clips on it. And but the only thing is you have to stay with your shredded paper, your shred till it gets done. We got stuck with a bunch of pretty sensitive information a couple years ago, and we had to get rid of that ourselves. We had to take it to Tulsa ourselves, and we just don't want to be responsible for somebody else's identity theft potential laying around in our garage. So stay with your document shredding till it's over with, and you'll get a certificate for a secure shred, and you'll be able to drive off. I know it.
Now, before you get away, let me ask you about that secure documents. Now, what are we talking about? Tax information, business receipts stuff?
Yes, receipts, income tax. You're supposed to get rid of them after about 7 years. I've still got some back from I don't know how many years, but and then I have a box of just the old checkbooks where I've torn them off, and I have an abundance of checkbooks. We'll shred those too. For you too, but any type of sensitive information that you may want shredded, so you don't want that information out there, credit card receipts and different payments, and you want that all shredded up. So that's basically when we do that, and we do it also available for our departments that have household contents, social security numbers, tribal cards. We don't want those out either, so we'll shred all those for those various departments.
I presume that would include the plans for your nuclear arsenal stash.
Yeah, those,
things like
that top secret stuff too that you need to shredded too.
How to print out an M1 tank or something like that.
Yeah.
Okay, now we've talked to you about recycling in the past on different programs. Earlier this year, we spoke of an event. Are these connected? How does that work?
This is just one of our big events here. This is one of our larger events, America's Recycle Day. The other one is the Earth Day that we'll have in the spring. And this year, coming up for the Earth Day, that'll be our 10-year celebration. So we'll go a little further out on that. Also, there's 2 events in between those, and those are our hazardous waste material collection times, but those are starting to grow too. So we can't do it all at the same time. That's why we had to kind of split them up. The hazardous waste, and then the other big recycle days. But so we have 4 altogether a year. But the biggest ones are the America's Recycle Day, which is this Friday, and then also the Earth Day, which will be some in the spring. I'm not sure. It's around April the 15th, and this one's usually around November 15th. But we like to do it on Friday because we get a little more response out on a Friday, and then volunteers are. I don't know if I'm going to get very many volunteers this Friday, Mr. Gary, because it's supposed to be a little kazupke.
Yeah.
Yeah, it's going to be a little cold, but that's why we call it a curbside, so they can pull up, and we will unload your recyclables or your whatever you got in your trunk, your electronics. Yeah, so we'll unload it for you if you don't want to get out. Of course, you're more than welcome to get out and visit with us, but we may not have too many takers on Friday.
Any hot dogs this time?
Oh yeah, we will. We got to have that. That's our staple.
Okay. Keeps your crew there from going off to lunch.
That's right. That's right.
Yeah, the 4 events are all separated, and from what I'm hearing, there's an indication they're becoming more popular. Your shredding truck fills up very quickly, I understand.
Yeah.
And give me an assessment there. Give me a feel for the increases that you're seeing, or people leveling off. Is it more popular now and more useful, so to speak?
Well, you'd be surprised since we've gone through the COVID era, and people were at home, and I think they were. Once people were at home the last 2 years, it seems like we got a lot more cardboard. It seems like everybody was ordering off Amazon. And then they are also cleaning out some closets, some cabinets, and now we're getting some stuff that they hadn't seen in years. And so they're bringing it out to be shredded or to be recycled. Some of the old electronics that you have that you didn't know you had, or you thought you were going to get it fixed, but it just didn't work out for you. Some of the old TVs and different things that's been around the house for the longest. And now they have that opportunity to get rid of those. And we have seen an influx the last 2 years. Seems to be growing, which is good. Getting the word's getting out there to just not throw your stuff in the trash and end up in a landfill. The landfills are getting so full now, and this is the one way that you can have your part in the earth and do the right thing and recycle these items, and so they won't end up in a landfill.
What happens to the stuff that is recycled? Do you disassemble it, or does somebody come and pick it up and then take components out of it? What happens?
Yeah, we work with a group out of Tulsa. It's called Natural Evolution, and they do our electronic recycling for us. And it does cost. There's a fee associated with that, but we don't charge any of our clients or our citizens or people in the surrounding area for any of that. But we'll absorb the cost. It's so much for a TV monitor and different things. But they take that, and they have a group that comes in, and they will take those apart. They'll try to recycle the plastic, and then they'll try to recycle some of the wire that's in there for reuse.
Well, let me explore that for a second. Are there any other valuable components there that get salvaged? I would assume, the wire and the plastic, but any other exotic metals or something like that?
Yeah, I think there's a few that they look for. They always look for the lead. Take the lead out, and I'm really not sure exactly. They're looking for the connectors and different things in there that they can probably use. So, time they get through it, there's not much left of it. Time they tear into them and get what they want out of it, it's just not much left. We are taking TVs, monitors, cell phones. Just about anything that's of the office electronic side, copiers, old scanners, We've really got some big TVs in the past, but the big thing is they don't really need the old TVs that have the old wooden cabinets. You know, when ours went out, we just put another TV on top of it. And it was kind of like our stand, you know.
Yeah, it became furniture.
Yeah, it became furniture. So no wooden cabinets. Of course, we hadn't seen any of those in a long time, but telling my age now, but they used to make some monsters.
Oh, I remember. I've come over there a few times and seen some
Yeah.
huge things. I think, my God, how many guys did it take to move that?
Yeah, I asked a gentleman, that older gentleman, and he came and I said, "How'd you get that big TV in the back of your truck?" And he said, "Oh, I had all my grandkids load it for me." I said, "You must have had a half a dozen." He said, "Yeah, it must have been a half a dozen because we used a forklift to get it off."
Oh, my
You
God.
know, so that's how heavy that was. You know, so we are taking white goods this time, small appliances. Washers, dryers, old dishwashers, refrigerators and freezers, and it says on here it must be empty and the doors removed. But if you've got it empty and cleaned out, where we can just look inside, we're good. You'd be surprised at some of them that try to leave dishes in an old dishwasher.
Oh, yeah.
You
Some
know,
of them are
Yeah,
that are growing molds that
Yeah.
are about to conquer the earth.
yeah, we really don't need that, and they're more than welcome to take that out. And take the leftover food if they have any in there. We had one that had tape all around it, and we was wondering why the tape was on it. And when we moved it, we realized why the tape was on there. So,
Oh,
so
were you really disgusted to find out?
yeah, we were like, oh man, that's not going to be recyclable.
Now, we usually hear some cautions about taking the doors off of refrigerators and freezers. That
Yeah.
a safety thing.
Yeah, it needs to be off anyway. It's a kind of a safety thing, so kids won't get in there and shut those doors on themselves. So I do see that more now with the doors removed because of that. Even if you have an old one out in the yard or on your back porch, you still need to take the doors off so somebody won't get trapped in there like a small child.
Let's talk about some of the other items that you are accepting. You mentioned white goods, but batteries from cars and
Yeah, we take just about all battery sizes except the lithium batteries we do not take, but we'll take all the AA, AAA, C, B, D, whatever we got, and we'll recycle all those and the car batteries. Tires, we're taking tires. That seems to be another big thing that we have. You got any old tires laying around you need to get rid of? Bring them on out and we'll take them. And we're taking sizes 14 to 22 inch, but we don't take any tractor tires, semi tires, ATV, motorcycle, or bike tires because that doesn't fit in their machine. They've got a machine that's got a chute, and they just roll those tires in there and it shreds them up to make. That's what they make the mesh for the different playgrounds, or they're making it even to where they trying to recycle that into different products now. So I'm not for sure exactly what they make with that, but they're starting to branch out to do other things. I know some of that goes into like the artificial football fields. So I'm not sure exactly how that process works, but I know that's what they're trying to do.
right, right. You've also got a little caution here: no lithium batteries. Let's run back to that. Where do you usually find a lithium battery?
A lithium battery will be in those batteries, and you see those now in all the like the power tools.
Okay.
You know, like a 20 volt or 18 volt, that type stuff. You know, the lithium batteries, and they'll have some type of marking on there that it's a lithium battery.
Is that like a hand drill or something?
Yes. Yeah. Yeah.
Okay.
Those are more lithium, and
Okay.
so we can't recycle those.
Are those the batteries that explode and burn up and?
Those are the ones that do that.
Okay, and take out a Tesla or something like that.
Yeah.
Yikes.
Yeah.
Okay, let's keep going here. Now, let me ask you about plastic bottles,
Sure.
1 and 2, and aluminum cans. Now, how can you tell whether or not you've got a 1 or a 2 plastic bottle?
It's usually if you just turn that bottle upside down, just like that water bottle that you have on your desk right there. If you can turn that bottle upside down, it'll have the recycle arrow triangles, and inside that arrows, you'll have a 1 or a 2 on there.
Okay.
So one is like just a regular water bottle. A two may be a plastic milk jug, or a laundry detergent bottle. Just turn it up and look and see what's in that triangle of arrows, and you'll see the number listed on there. We don't take anything more than a two. I wish we did. Solo cups are like a 5 or a 7, and we just don't take that.
Okay.
But we don't have a vendor that takes that just yet. But
Okay, I suppose I better screw the top onto this bottle before I turn it over. Then, huh?
yeah, put that lid on there. But and then if you do have a detergent bottle or a milk jug, we'd ask that you rinse that out for us, and then put the lid back on. It's fine.
Okay. Let me see, where we got aluminum cans.
Aluminum cans, yeah, that we'll take aluminum cans, and we'll take just about any size aluminum cans. We're not taking at this time any tin cans. That'd be like the big vegetable cans. We're not taking those right now, and we don't take any glass. I wish we did, but glass is so heavy. We have trouble moving it. You got to have a place for it, and then you got to have a big forklift to load that and then dispose of that also. So
Does it pose more of a danger to your crew?
yeah, because it takes up a lot of space and it's real heavy.
Yeah.
So they still collect it, but we just hadn't done it yet. We have several people that come because they have a different array of bottles or beer bottles or wine bottles that they want to recycle.
Okay. Let's take a look at some of the hazardous materials. I know we've kind of skimmed over it there, but what does that include, first of all?
Yeah, the hazardous material is the one that we just had. We just had a collection event in October. That's the various paints. You know that paint is actually flammable. So if you have some paint, you can't bring any paint. But one way you can get rid of that paint is just open up the lid and let the thing dry out. So if it dries out, then it becomes non-hazardous, and you can just throw that in the trash. But medication, we're not taking any medication, any glues, varnishes, anything like that. We're not taking lithium batteries, fluorescent bulbs, or chemicals as pesticides, herbicides, cleaners, insect repellents. Those will not be accepted at this event. However, we will be doing that again next year, and that seems to be getting a big draw. We were able to fill up a whole box truck of hazardous waste the last time we did that, Mr. Gary, in October. So that's good. That's what we want. We don't want those falling into the hands or getting broke in somebody's garage or inhaling some of that stuff. So I know that's a good thing. People cleaning their garages out, got some stuff on the shelf. We've seen some stuff from the 60s and 70s that come through there. Had the old skull and crossbones on there. I thought, man, I hadn't seen that since 60s or 70s. Looked like some DDT.
It's petrified by
yeah.
The change in part of our cultures these days is to get rid of the old light bulbs and replace them with LEDs. Are these included in what you collect, or do not bring them? Where does that come down?
Yeah, we're not taking them right now, but we do take them when we do our hazardous waste collection. So if they've got them, just hang on to them, and we'll do it again in the spring sometime. We'll do our Earth Day, and then we'll probably do a hazardous waste collection in May sometime. But we kind of space them apart, so. The Earth Day will be in April, so we'll either do one in March or in May, just depend on our schedule, what our schedule looks like. But hang on to those, and then you can bring the light bulbs then.
Okay, good. Are there any other items there that we should probably mention on the do or do not lists?
No, not really. Just the one I want to touch base with is on the electronic recycling. We're not going to take a bunch of lamps and a bunch of stuff that would just. We used to take anything that had a cord on it, but we've gone past that because some things they brought were just way out of line there. We couldn't use. We couldn't even recycle them. There wasn't much there to them. They were the big freestanding lamps. and different items that had a cord on it, that we just couldn't do. So we're trying to mainly hold it to items that you would find in your office, your home office, or your office at work, and your electronics with your computers, computer monitors, and keyboards, and printers, and scanners, and all that good stuff. And every now and then we'll get an old VCR.
Gosh.
We'll ask them, does that still work?
Any betas?
Yeah. We do get some betas, and then we did get an 8-track tape
Oh my God.
the other day, and I said, "Oh, now we're showing my age here, because I know what that is."
Yeah, I remember when that was the hot thing.
Oh yeah, got to have 8-track tape, and then it'd get a little loose, and you had to put popsicle stick in there or something in there to hold it up. So.
Those were such fun when they first came out. People were just amazed that they could carry their music with them like that. But the thing that always irritated me is it get it right in the middle of a really hot song and then switch tracks.
Yeah.
Chunk in the middle of your,
Yeah. How about the cases that you carried them in?
Oh God.
You had a little case, looked like a toolbox,
Right.
So.
If you dropped it, it always popped open.
Yeah.
You looked like an idiot picking them up. Now we're seeing that our folks are responding. And is it? I guess it's just more popular idea, or people are more concerned about the Earth. What do you hear?
I think it's a little of both. I think it's a good educational phase of it that's starting to take hold. You're starting to see more out there about going green and recycling and doing the right thing. And once you get to throw something away, if you'll take just a second to say, can I recycle this, or do I just throw this away?
Mm-hmm.
We've done our part then, because now we got them thinking. We got them thinking about it. So, and everybody likes the blue bins, but really you don't have to recycle in a blue bin. You can put it in a cardboard box or a bag right beside your trash bag, and then you just make that conscious decision to either recycle or throw in the trash. And same way with your electronics. We're in the throwaway age now, where if something breaks, we'll just throw it away. But just know that a lot of those electronics can be recycled. So that's where we're at on the electronics.
Okay, in the last couple of minutes here, I know that your crew was coming around to different offices around the tribe here and collecting things like paper and whatever else. Do you still do that? I mean, is there something there that these departments need to respond to?
Oh yeah. We still do that. We're trying to get a little further along down the road and put different locations where they can bring their recycles to on the campus. And so that's what we're trying to focus on now, because we used to go to each department but going to each department was taking a lot of our time. So if we can just get a central location, we have a couple at the complex where you can take your recycles to. And then also we're still doing some schools. We still do the college. We do some furniture stores. So it keeps growing. We get calls all the time if they would like to join the program. Sometimes we can, sometimes we can't. And sometimes it's a call in when they get full. That'll save us some stops instead of checking on them every week. Not everybody will use it every week, so it's a work in progress about when to stop and when to pick them up. But also, it's going to be short week next week, so if we miss you next week because of Thanksgiving holiday, we'll certainly pick you up the following week.
Okay, no turkey bones.
No turkey bones.
Okay, no bun one there. Okay, well, I tell you what, let's run over the logistics involving this event once more, and we'll move on to a second portion of our program. But first of all, let's hear the logistics there.
Sure. Our America's Recycle Day is coming up this Friday, November the 18th, 2022. Starts at 9 and goes till 3, and we'll have a shred truck there from 10 to 1 o'clock. It's at the Mvskoke Creek Nation Recycle Center, which is located right off Gun Club Road at 1267 5 Gun Club Road here in Okmulgee, and we're just right across from the I'm not sure who has the Chevrolet dealership, but we're just strictly to the west there. You turn at McCoy's and then go a couple blocks, and then we're 1 block north right there. Hope everybody comes out, brings your recyclables. I know it's going to be cold, so if you don't have to get out, we'll come and get it out for you. So
Okay, well, if you can find the Fleet garage, then you guys are behind them.
we're behind that, yeah.
All right.
We're
Well,
there.
Mr. Williams, thank you once again for coming in and filling us in on this really useful program, and we hope you have a lot more success. Keep us posted. We'll do our bit here, too.
Thanks for having us, Mr. Fife. We appreciate the time.
Okay. Well, we're going to take a short pause here, and then we're going to listen to some of the opening arguments in the Indian Child Welfare Act case that went before the Supreme Court this week, and we'll try and make sure we can get you some proper identification for some of the people involved. But that segment will open with the Brackeen attorneys, and then in the second part we'll have the people defending the federal law and Indian tribes. So stay with us here on Mvskoke Radio. We're back here on Mvskoke Radio, here on the Brew in beautiful downtown Okmulgee, 106.3 FM and 1240 AM. We have been watching the Supreme Court's activity here, and we have downloaded the arguments that went before the court this week. Since that whole session was like 3 hours long, we knew we couldn't bring you the whole thing in its entirety, but we have lifted some excerpts from the opening arguments from the Brackeen family and I guess the state of Texas. And then in the second segment, we'll hear from the attorneys for the Interior Department and federal laws and, of course, tribes. So please check this out. We hope that we find this informative. And, of course, a lot of it is legalese, so I kind of sometimes have a tough time with it. But we hope that you can find all this information useful. So, Madhu.
Counsel, you haven't challenged the regulation.
Yes, we have, Your Honor. We have a challenge to
But not in the cert-granted question.
Your Honor, we raised a challenge in our complaint to the...
I'm not asking about the complaint. The cert-granted question does not include challenges to the regulation.
It challenges
the statute.
We challenged the regulation as an unconstitutional, as an implementation
Counsel answered the question. Is it part of the question presented or not?
I believe it is, Your Honor.
Did you seek cert on that question?
We did not seek cert on the question of whether it is a permissible construction of the statute. We sought cert on whether the statute...
So if you don't seek cert on that, there's nothing on that good cause standard.
I don't think so, Your Honor.
Counsel, can I turn to something you said, which was it displaces the best interest of the child standard. In most state custody proceedings, the best interest of the child is what guides those decisions. Yet we have the Hague Convention on the Abduction of Children that basically says to the court, you can't make that determination. You have to send the child back, and it gives a section of exceptions, etc. And it even says standards of proof, etc. Why is this case any different than the Hague Convention?
For, I think, a couple of reasons, Your Honor. First, The Hague Convention, as I understand it, would send the child back to their place of their habitual residence.
But that's not necessarily in the best interest of the child. There's no best interest standard there.
What I was, if I might just finish my thought, Your Honor, that habitual residence standard is essentially duplicated in Section 1911A, which provides for tribal courts to have exclusive jurisdiction concerning children who are domiciled on tribal lands. So I think that parallels the Hague Convention. The other,
well, how? Meaning these children are in the U.S., they have a relationship with an Indian tribe over which we have recognized for over 2 centuries Congress has plenary authority. If Congress in one enumerated power can supersede a state standard, why can't it in another?
Well, Your Honor,
they can say the best interest of the child shouldn't be the top test or only test, either good cause or something else, as ICWA does. Why is that beyond Congress's power?
I'm not aware that an equal protection challenge has ever been presented to the Hague Convention. If you're referring,
you think that Congress's foreign affairs powers don't permit it to legislate with respect to the relationships of a foreign country and its competing custody issues?
Your Honor, I think the foreign affairs power is subject to the Fifth Amendment. I think the question of whether citizenship would rise to the level, a classification based on citizenship would amount to race discrimination, would essentially be the question of whether citizenship is being used as a proxy for race.
Counsel,
the government,
to what extent is the best interests of the child, or the same considerations that are taken into account under the best interests of the child, incorporated in the good cause showing that could be made under ICWA?
I would say that they are not, Your Honor. I mean, the good cause standard is a holistic standard that takes all of the child's circumstances and needs into account. What the good cause standard does is sharply limit that under the 2016 rule to enumerated factors. In the 2013, when the adoptive couple case was before this court, the government described the good cause standard as a safety valve. That's footnote 2 of its brief. It is no longer a safety valve. The Interior Department has promulgated these regulations with the specific purpose of making it limited, narrow, and, in its own words, not a best interest test. So it differs very much from what would be the traditional best interest test.
So how do you understand this to work? I mean, if you have, for example, an Indian couple, non-tribal members of the tribe of the child, exactly how does the state court adoption authority take into account, how do they weigh the interest of the non-family tribe member against, you say you don't take into account the best interests of the child? What are you weighing on the other side?
Well, I think you could look to the Texas Court of Appeals decision in the YRJ case as just an example of this. So the question is whether the person challenging the placement preference has shown one of the enumerated factors by, at that time, clear and convincing evidence. That standard of proof has since fallen by the wayside. So that's how it plays out on the ground, is one of those 5 factors demonstrated by preponderance of the evidence. It doesn't, it does not, those 5 factors don't take into account the bonding or attachment of the child, which would be the most obvious and most compelling part of the best interest standard. It only says if there's a showing of extraordinary needs that is not just something that is from what the regulation describes as ordinary bonding and attachment, that good cause can be shown. I mean, after the 2016 regulation, the placement preferences are effectively dispositive in many cases.
Counsel, can I take you to the scope of the Indian power? We've described it as plenary. It's quite broad, and in area after area, we've allowed Congress to far exceed anything that we would think of as just commerce in the sense of trade, which is something that you've floated. Are you asking us to overrule all of those precedents?
No, Your Honor. I'm not going to speak for my colleagues from the state of Texas, but for our part, no, we're not. We don't think you need to overrule any of the precedents.
Because you'd have us just focus on the equal protection.
No, Your Honor. I mean, on the Article I piece, this cannot be understood as within the Court's Indian Commerce Clause precedents. It's not commerce in any normal sense of that word. The question is then whether it is part of the plenary power that otherwise has been described in this Court's precedents. And our submission is that plenary power is, if you in the Court's cases, as elaborated in this Court's cases, that plenary power applies to the tribe's areas of its sovereign interests, tribal lands, treaty powers, its internal affairs, its ability to self-govern. It's not a power to regulate Indians everywhere, wherever they might be in the jurisdiction of the United States.
So what do you do with that line of cases, like the Act of 1888, setting the evidentiary standard for proving a marriage in cases involving an Indian woman and a white man? That wasn't limited territorially. That set an evidentiary standard. Or the Trade and Intercourse Act of 1834 set burdens of proof in all trials, whether on reservations or outside of reservations, about property rights between Indians and non-Indians. The Act of 1799, state courts must take proper bail when federal officers detain offenders who trespassed into Indian territory. So that one arguably had something to do with that, but there's a legion of cases, as Justice Barrett alluded to, where Congress has gone off of Indian lands, had nothing to do with sovereignty, had nothing to do with trade or commerce, but with intercourse, with the relationship with Indians, whether on or off reservations.
Well, Your Honor, I guess I would have two parts to my response. The first is that the Constitution confers an authority to regulate commerce, and that power, as understood as Justice Thomas's separate opinion and adoptive couple, I think well
But that was
elaborates.
a separate opinion. We've described the power as more plenary than that.
Well, I think this is just the fundamental portion of my submission, and I respect the fact that we might not agree on this, but that there is a commerce power that allows the government to regulate commerce wherever it happens within the United States. And then there is, in addition to that, a plenary power that allows the government, the federal government, to regulate the tribes, and that arises from the federal government's role as the subjugating sovereign of the tribes, and its role as now under CAGMA, the protector of those tribes. But that power is not unlimited.
Why is it limited by geography? You're suggesting that the plenary power that you describe, is limited by the tribal land demarcation. And I don't understand where that comes from.
Well, I don't think it's just tribal land, Your Honor, although as this Court's decision in Plains Commerce Bank says, that is the core of tribes' sovereign interests, but it also would extend to treaty rights, the internal affairs of the tribe, and the laws that address the scope and form of tribe self-government.
All right, so you concede that Congress has plenary power over tribal sovereignty and self-government, then?
I believe that Congress absolutely has the power to adjust and change the scope of tribes' power to govern themselves.
All right, so what do we do with the legislative history in regard to this act, in which Congress repeatedly referred to the kinds of restrictions and regulations in this area, in ICWA, as a matter of tribal governance and self-government and sovereignty. I mean, Congress said things like there's no resource that is more vital to the continued existence and integrity of Indian tribes than their children. They constantly cast regulations regarding children, Indian children, as a matter of tribal integrity, self-governance, existence. So why isn't that enough to bring it within the scope of their plenary power?
Addressing the tribal existence point, I have 4 responses to that. The first is that the third placement preference doesn't even rationally advance that objective. Placing a Seminole child with a Cherokee family doesn't rationally advance the existence of either tribe. The second point is that placement does not dictate membership. You need only look as far as YRJ to show that.
Right, but I feel like you're in the weeds of the actual regulation. What I'm asking you is the broader question about whether or not Congress has the ability to regulate in this area. So I understood your response to Justice Barrett to be not anything outside of commerce or the plenary power expanding to or extending to self-governance and self-regulation. So I'm just asking as a matter of characterization, why aren't regulations that concern whether or not Indian children are going to remain in the tribes fitting within that plenary power?
Your Honor, in Williams v. Lee, this Court described the power of self-government as the power of reservation Indians to make their own laws and to be ruled by them. ICWA has nothing to do with that.
Counsel, I'm struggling to understand your argument. For the first half of it, I heard policy complaints. It took a while for me to even hear the words equal protection or Article 1. And I guess I'm curious, first of all, which do you think is your better argument? Legally, not the policy arguments might be better addressed across the street.
Justice Gorsuch, we are here to advance both arguments, but I'd like to talk about the equal protection argument.
Okay, so if the equal protection is your better argument, what do we do about your standing problem? You've sued federal officials, not the state courts who actually are tasked with operating.
I think my answer to that, Justice Gorsuch, starts with the traceability standard, which is de facto causation. And then I would say
no federal official can dictate to a state family court what to do, can he?
I'm sorry, I did not hear the question.
Can any federal official that you sued tell a state court what to do?
No, Your Honor.
Okay, I would think that might be the end of it.
Okay, we'll take a short pause here. That attorney being questioned by the Supreme Court justices was Matthew McGill, representing the Brackeen family and 2 other families in other cases. And in the second half of our presentation, we will be hearing Edwin Needler, who is arguing for the Interior Secretary Deborah Haaland and, in essence, Indian tribes around the nation. So please stay with us here on Mvskoke Radio. Welcome back to Mvskoke Radio here on the Brew. We are going to proceed now with the second segment of our excerpted material from the Supreme Court hearings regarding the Indian Child Welfare Act. You will be hearing Attorney Edwin Needler being questioned by the Supreme Court.
As this court recognized in Holyfield and Adoptive Couple, ICWA was enacted in response to serious harms caused by widespread child welfare practices that resulted in the separation of large numbers of Indian families, often unwarranted, through adoption or foster placement, usually in non-Indian homes. Over the more than 40 years since its enactment, ICWA has furnished vital protections against those practices and has become integrated in state child welfare practices. There is no basis for uprooting those practices or for overturning Congress considered judgment in enacting ICWA. ICWA, in fact, is a valid exercise of Congress's power over Indian affairs in several respects. That power is grounded in the text of the Constitution, including the Indian Commerce Clause. It is grounded as well in the constitutional structure, in which Indian tribes occupy a unique status as dependent sovereigns to which the United States owes a duty of protection. And that duty of protection, as this court observed in Kagaba, derives in large measure from the fact that the national government and the states aiding it, acting through treaty and war powers, diminish the tribe's ability, put them in a position of dependency, and as this court said in Kagama, Sieber, and other cases, gave rise to a duty of protection, which in turn encompassed a power of protection. Congress's efforts to address the problems in ICWA, protecting family integrity, kinship unity, and the integrity and long-term existence of tribes lie at the core of Congress's power under the plenary powers. It does so not by displacing state authority, but simply imposing minimum standards on states' exercise of that authority by seeing foster care and adoption in state courts. Petitioners' plea to this court to set aside ICWA on its face would undermine those vital protections that have worked well, as the amicus brief by 23 states shows, since its enactment. It would also gravely undermine this court's Indian jurisprudence by carving up Congress's plenary power into discrete categories which this court has never recognized. And it would undermine the reliance of Congress, of tribes, of individual members, and here states on Congress's exercise of power.
Well, Mr. Kneedler, if the plenary power has no limits, then of course there isn't any Article I issue for us to decide. Does it really have no limits in your view?
No. Mankari announces the core of the test, which it has to be rationally related to the fulfillment of Congress's unique obligations to Indians. So in that, it is an implementation of the dependent status and the protection, whether that comes just from the Indian Commerce Clause or the amalgamation of Congress's various powers. But it has to be in service of the obligations to the Indians. And this court in Mankari said it has to be reasonable and rationally related to Congress's fulfillment of its unique powers. There is, I think, a reasonableness there, but this is at the core of something that is
so rationally related. Is that our usual rational basis test?
I think Congress's judgment, whether it does serve that purpose, is entitled to great deference. I think it may not go all the way to rational basis because I think it's important to recognize that Congress has acted over the 2 centuries since the adoption of the Constitution in pragmatic ways when it has been confronted with a particular problem. It has assessed that problem. It has come up with what it regards as the appropriate solution to that problem and has acted in a reasonable manner, and this court has said that deference to Congress's judgment about what is reasonably essential to carry out the trust responsibility is called for.
Could Congress say —
No, go ahead.
Could Congress go further than it has gone in ICWA and say that an Indian child may not be adopted by a non-Indian couple under any circumstances?
I think that would obviously go further, and I would want to know the circumstances, but I would think that would be a difficult law to defend.
But that's not rationally related in the same way that this is? I mean, it's more — I honestly don't — I've had great difficulty dealing with this Article I question, because if plenary means plenary, Congress can do whatever it wants, fine. As I said, it's an easy case. There's nothing there under Article I. But if there are limits, it's hard for me to see where the limits are. That's where I need help.
Well, I think the place to start — frankly, I think it's difficult to state one rule that applies across the board in all the various circumstances where Congress might act. Criminal laws, education and health care, as Justice Gorsuch mentioned, child welfare. But what this court has said, and again, I want to come back to this. Sieber was an example where it involved tax exemptions for property, but the court in upholding that said these tax exemptions are appropriate in aid of Congress's carrying out its obligation.
What about the boarding school law? Congress have the power to do that?
Congress had the power at the time, I think.
Well, if it were to do it, if it were to do it tomorrow, would that fall outside Congress's plenary power?
Well, it has to be the plenary power. I think there are at least two things to bear in mind about this. I think Congress, when dealing with a tribe in its political capacity, has a great deal of power to diminish the tribe's or regulate the tribe's exercise of its governmental authority, like under the Indian Civil Rights Act, et cetera. That's dealing with the tribes as tribes in a political capacity. I think where Congress is addressing the protections for individual Indians, either children, adults, whoever, then that's what triggers the formulation of the trust responsibility or the dependent status of tribes. It has to be reasonably related to Congress's unique obligations to Indians, which means it has to be protective, not harming.
Could Congress enact a law that alters the substantive law that states apply in areas like contracts or torts or rules of evidence when one of the parties in the case is an Indian?
I think the mere fact that the party is an Indian would probably not be sufficient.
Why? Why isn't that rationally related to furthering the interests of Indians?
I think in examining any hypothetical statute or context, it is necessary to look at the judgment that Congress made and to know why Congress made the judgment that it did. In Indian contracts, for example, there were many, many years where contracts by individual Indians were not valid unless approved by the Secretary of the Interior because of a concern that they were going to be taken advantage of. So if there was that sort of justification, and presumably, I don't think we can assume Congress would act in an arbitrary manner. It would be addressing a real-world problem in a practical way.
No, I understand it. And
no, go ahead.
Just one more. Honestly, I don't know how to analyze this question because if plenary means everything, then it means everything. And otherwise, what I've gotten from the briefs and the arguments is that we have to try to extract certain rules from our cases, which quite honestly strike me as a mishmash. But one last one. Could Congress have required that Indians get preference in receiving the COVID vaccines? Would that be an equal protection violation in your view?
Again, I think it might depend. If Congress decided to furnish vaccines to tribes as part of a tribal health program, I don't know whether you would call that a preference or whether that's aspect of Congress's delivering health care. It might have a disparate impact, if you will, but Congress has a duty to Indians, and it might buy a lot of vaccines and deliver them. But a prescription to a state, for example, might be quite different.
I do want to follow up on Justice Alito's question. There's a limited number of vaccines. Can the federal government decide to distribute those to Indians and not others?
Well,
it's a very simple hypothetical.
Well, probably not, but I just want to caveat.
So the plenary power doesn't include something like that?
Well, answering what plenary power means, I think several things that it means. There's no subject matter that is completely off limits just because it's Indians. There is no geographic component which renders something completely off limits.
But there's something about distributing vaccines with a limited supply that is, you suggested, I guess, that it may not be within the plenary power.
Well, in a court's reviewing of something that Congress has done in the exercise of its plenary power. Again, the test the Court has applied, it's used different formulations. But
is that the reasonably essential?
Reasonably essential, appropriate, not arbitrary.
What I mean, if it's essential, it's essential. If it's but what's reasonably essential?
Well, reasonably essential is not a familiar term in the way.
In English?
Well, but in jurisprudence, but that's followed by deference has to be given to Congress. And you know, if the furnishing of vaccines to the tribe was part of a general program to furnish vaccines to underserved communities,
no,
I mean, it would depend.
No, I guess this is the point. You're arguing for special treatment with respect to Indians. So why does it matter if it's part of a program to serve underprivileged communities?
It may not, but I don't think Congress has not done the sort of thing that you are describing.
But
Congress
Mr. Kneedler, I thought that your answer to the Chief was going to be that issue was not really teeing up a question about the plenary power, that the issues that they have identified, I would think, would be analyzed under the Equal Protection Clause, and that's sort of a separate constitutional basis for
that would be, although that also has a rational basis.
Well, but there are two questions. One, whether you can do it in the first place, which is the plenary power question, then whether you can do it in a way that distinguishes between polities with which the federal government has a special trust relationship.
I think these two questions raise, and it may all be under the plenary power, they raise an ends mean. There's no doubt that furnishing vaccines to Indians, at least if they have some tribal connection or within the scope of people eligible for Indian health care services, there's no doubt that that is a valid mean or a valid end for Congress's action. The question would be whether the approach it took is a reasonable one or rather it is arbitrary. And those require some assessment of Congress's judgment to which
I mentioned to Mr. McGill difficulty understanding how the placement priorities work. So maybe I'll try an example. Let's say there's a 6-month-old baby that had been born to an Indian couple, and the Indian couple, for whatever reason, is no longer there, and there are also no extended family members in the tribe. A non-Indian couple comes forward and says, we would like to adopt the 6-month-old baby, and they check all the boxes under, best interest of the child. In other words, in normal circumstances, this would be a perfect placement for the child. But non-family members of the tribe say that, no, they think it would be better for the child to be raised with the tribe on the reservation. Does that priority trump the other best interests finding?
Well, several questions about that. When Congress enacted, when Congress enacted ICWA, it was very concerned about the application of the best interests of the child standard because it led to subjective judgments by state welfare.
Well, let's assume that it's a good faith and reasonable application of the best interest standard.
But what Congress did was to adopt objective standards, which is the child, which is the priorities, and with respect to tribal members, there is an extended kinship proposition there.
So does that priority displace the state court, state adoption agency determination of the best interests of the child?
Well, the agency would have to determine that the tribal family was qualified, first of all, and then secondly, that placement. It's a rebuttable presumption and is not absolute. So there is a good cause.
A rebuttable presumption that the child would be placed with the non-family members of the tribe.
That's one way to describe it. But then yes, I mean.
So my point is that in that particular situation, the best interest of the child would be subordinated to the interests of the tribe.
No, but
the interest of